Welcome back to this course on copyright and related rights law. In today's session, we are going to be continuing our discussion on copyright societies. We have already seen how copyright societies are functioning. We had understood that a copyright society works as a bridge between a copyright holder and the user, and the entire gamut of activities which are necessary for an effective management of copyright is undertaken by copyright societies. In carrying forth that discussion, we will be looking at certain issues in such functioning. Take a look at this image. We have considered this image in the previous session as well. But ask yourself, is only a composer interested in the communication of the music in the plane? We had discussed that a copyright society will connect such an authorization for communication of music on the plane with the right holder. So the right holder will authorize such a communication through the copyright society, and the copyright society will then ascertain utilization and collection of revenue and distribute it to the right holder. But where such a communication happens in the aeroplane, is it only the composer who is interested as a right holder? We must then understand, how is this communication happening to passengers? Let us understand that music is not being performed on the aeroplane. Rather, music is being played through a device. And where such a communication happens, a recording has to be played. And because a recording is being played, it is a sound recording that the passengers are listening to. In the sound recording is a constituent musical work. You will also realize that for sound recordings that are essentially composite works, we are considering the existence of other underlying works as well. For example, there could be literary works also. But nevertheless, in looking at this particular image and this particular question again, on who is interested in terms of copyright with respect to that communication, we can then see that music labels, composers and lyricists are all interested parties in such a communication. Because when a passenger listens to this sound recording, he is in fact appreciating not just the sound recording, but he is appreciating the music and the lyrics as well. Can we extend this understanding to films as well? When we watch a film, who is the interested stakeholder? Is only the script writer the interested stakeholder? Clearly, he is only one interested person. There are other interested people as well. For instance, the music producer, the composer, the cinematograph film producer, all of these entities are stakeholders within the realm of films as well. Therefore, although it is only a sound recording that is being played, and although it is only a film that is being shown, the interested parties are also parties who are underlying work authors. Consider, what if the music was being communicated and not the film? In this example, because the music that is communicated to the film watchers is being communicated on account of the film itself being shown, what if the music was separated from the film and then utilized for the music itself? We have seen that the Indian Supreme Court, in a very important decision in 1977, in IPRS versus Eastern India Motion Pictures Association, has stated explicitly that a film producer can defeat the right of the musical composer through the application of 17B and 17C. To quickly recall what these provisions stated, you will remember that Section 17B spoke about making of a film for a valuable consideration, wherein the first owner will be the person at whose instance the work is made, which will be the producer. And second, where it is a contract of service. Even in such a situation, the film producer will be the first owner. We had seen that because the film producer is the first owner of the underlying work, there is no independent usage of that work that can be made by the film, by the music composer. What the 2012 amendment inserted in Section 17 was a proviso which read, as you can see on the screen, provided that in case of any work incorporated in a cinematograph film, nothing contained in clause B and C shall affect the right of the author in the work referred to in clause A of subsection 1 of section 30. What this proviso has done is that it has overridden the application of 17B and 17C to defeat section 13 application. We had seen in section 13, which talks about works in which copyright subsists, that the cinematograph film work will not affect the separate existence of the underlying works, but 17B and 17C were giving first ownership to the producer, which this proviso has removed. And therefore, if the music is being communicated and not the film itself, then this is something which the composer can exercise for himself and does not have to depend on the film producer. Let us consider the alternate query. What if music is not communicated as separated from the film? In such a case, we have understood that a cinematograph film, which is a visual recording, would also include the sound recording which is forming a part of such a visual recording. which means that when a cinematograph film is being shown and the music in that film is being heard by audiences by way of such a showcase, then it is the film which is being communicated and not the music which is being communicated for the music itself. Having said this, and having realized that cinematograph films are standalone works, they are different from the musical work, is there still some connection that composers are having with the communication of the film? Because clearly, when a film is being shown, the music that is heard by the audiences, which is part of the film, that music is not inherently connected to the film itself, but rather to the composer. And therefore, can it be stated that the film is in fact a completely standalone and completely separated from the composition? We must then understand a very important consideration of revenue in copyright systems. Whenever there is an agreement over a professional relation to contribute a particular work, such as a relation, for example, between a producer and a composer, there could be a signing amount. Signing amount as in over the agreement on terms and conditions that are agreed between the producer and the composer, a certain signing amount is provided to the composer. Now, this signing amount would ordinarily take into context the services that are forthcoming. But because revenue is inherently connected to the utilization of a particular film, the producer would in effect be better off sharing percentage revenue from the profits that he is gaining from the market. And which is where we are arriving at a very important term which is used in copyrights: royalty. The term royalty is not defined within the Indian Copyright Act, but rather royalty, as we have understood it in practice, means income derived from future utilizations, which at the point of signing is not clear. So, for instance, if the agreement states that from the profit 2% or 5% royalty will come to the composer, then depending on whatever utilizations the film is being put through, for example, it could be an OTT agreement, an over-the-top agreement, such as with Netflix. It could be DVD sales. Through these, whatever revenue is coming in, there would be a certain percentage which will get connected with the composer, and that amount is what we are referring to as royalty. In terms of whether this royalty claim will exist even after a film has been released, and is this a mandatory claim, something which cannot be done away with by the producer, has been the subject of an intense debate as well as consideration by the legislature in the inclusion of a new right which in itself is being contested, called as a right to receive royalty. Because this is contested and something which requires in-depth study, this is something which we are looking at in much more detail in the later sessions of our course. But coming back to our discussion on copyright societies, because different stakeholders are involved in communication of a work, and these stakeholders are having their own common purposes. Copyright societies represent different works. You can see how registration of copyright societies can therefore be beneficial, because registration of copyright society can serve as an important tool for regulating copyright societies. Let us now consider the question of registration of copyright societies. Section 33 of the Indian Copyright Act, it says that no person or association of persons without the authority of the central government, in effect mandating registrations, can carry out the business of issuing or granting licenses. Copyright management organizations, CMOs, or in other words, copyright societies, you must have understood that because this is a collection of similarly minded individuals with a common goal in mind, it's possible that there are different such collections existing for the same kind of work. That is possible. But it is a matter of policy that a particular country can choose the manner in which copyright societies are functioning in their jurisdiction. In the Indian jurisdiction, Section 33 is talking about registrations of copyright society. This particular framework also requires that ideally there is only one copyright society for a particular kind of work. But with the exception of the central government, there can be more. If we consider the advantage of what this can pose, is that a single society can serve as a central node of regulation as far as the central government is concerned. The tariffs that will be generated by the copyright society, because these are being imposed on the public, there is a direct connection that the central government is having with respect to regulation of such societies. Therefore, where India has required registration of such societies, it is with a particular policy purpose in mind. In other jurisdictions, such as in the US, for example, copyright societies can be more than one in number with respect to the same work. And there is nothing in the statute which prescribes an ideal number of copyright society. Let us compare Section 33 requirement with Section 30. Section 30 of the Indian Copyright Act, it provides that copyright owners can engage in licensing. Quite naturally, because copyright owners are interested in authorizations for the purpose of revenue generation, such authorizations would be possible only by way of transactions, and these transactions would be licenses. So, in a case where a copyright holder has engaged in an assignment, which means supposing a composer has transferred his ownership over that composition to the copyright society, then we can say that now the copyright society is the owner. So what Section 30 is saying is that the copyright society can engage in licensing. You can therefore see a conflict that arises between Section 33 and Section 30. Let us consider other businesses which are engaged in the business of issuing or granting of licenses, where such businesses are not registered copyright societies. Let us consider PPL. PPL is Phonographic Performance Limited. The members of PPL are music labels such as Saregama, Sony Music. PPL was a registered copyright society. PPL is one of the oldest businesses which is engaged in the issuance of licenses with respect to works that have copyright in it. Another business which is in the business of issuing or granting licenses is Novex. Novex also represents music labels such as Tips, Z Music. Because these businesses are unregistered copyright societies, it has given rise to a question whether registration is a mandatory requirement, and if there is no such registration by a business, can it then engage in licensing? This question was taken up by the Bombay High Court in a case of Novex Communications versus Trade Wings Hotels Limited. As you can see, the court is considering the question whether organizations like PPL and Novex could carry on the business of issuing licenses without being registered as copyright societies under Section 33. In other words, does Section 33 prohibit any person or association of persons from carrying on the business of issuing licenses without registration? What we had also considered when we made a distinction between Section 33 and Section 30 was that because Section 30 is empowering copyright owners to engage in the issuance of licenses, if an assignment has been made in favor of such copyright society, or in other words, if we just call it a business, if an assignment has been made in favor of such a business, then Section 30 empowers them to engage in licenses. So, the court explains there is a clear distinction between the rights of copyright owners under Section 30 and the restrictions imposed by Section 33. It reasoned that carrying on business of granting licenses cannot be excluded from Section 30, particularly when such granting of licenses is by the owner of the copyright. The power under Section 30 to grant licenses by an owner has in no manner been denuded by Section 33 of the Act. What the court also remarked was that PPL and Novex had in fact filed their suits against rank infringers who had failed to obtain licenses for works they were exploiting. What you can see here is a policy prerogative. If indeed Section 33 is to be upheld, then it would mean that owners of copyright who are legitimate owners, there is a legitimate transaction between, say for example, the music label and such a business, then it would invalidate the effect of the licensing provision within the Copyright Act. According to the court, that cannot be the case. If that is in fact upheld, then it will give a kind of license to piracy, to infringement by rank infringers who would consider this as a leeway to not take licenses. Let us also look at a very important transformation that has happened to the Indian Copyright Act through the 2012 amendment. Prior to the 2012 amendment, copyright societies were under the owner's control. Owner as in the copyright owner. The legal reasoning here is very simple, that whatever a copyright society undertakes, whatever responsibility that a society undertakes, such a responsibility would have to be authorized by the original copyright owner. And therefore, in the management of the society itself, the primary concern is of the owner themselves. In fact, to supplement this understanding, we can consider the Supreme Court's decision in IPRS versus Eastern India Motion Pictures in 1977. We had noted that the role of underlying works in cinematograph films was something that the Supreme Court had stated very clearly can be defeated, wherein 17B and 17C were used. With the 2012 amendment and with the realization that underlying work authors should be given a fair, with the understanding that underlying work authors should not be completely separated from their work, and rather their connection to the work must remain even if the work is not being communicated separately but rather as a composite whole. The 2012 amendment has brought to the table collaborative sharing of responsibility between authors and owners. As we had seen, an important inclusion that has been made by the 2012 amendment is the right to receive royalties, which makes the underlying work authors right holders. And therefore, to say that owners of copyright only are responsible for the copyright society would be erroneous. Up until this point, we have discussed the interest of authors with respect to copyright societies. But what about performers? Performers such as singers Would it be possible to watch a film without performances? Would it be possible to hear sound recordings without performances? And therefore, just how a common purpose of management of copyright is important for authors, similarly, management of performers' rights is important for performers such as singers. In fact, performers' society, very similarly to copyright society, can be registered in India. With this, we have come to the end of week 6. In these 6 weeks, we have discussed 6 types of subject matters, 4 which are considered on the anvil of originality and 2 which are unoriginal but still have copyright subsisting in them. We have also understood the functioning of copyright societies. In the next week, we are going to be looking at related rights and specifically the related rights of performers' right. Thank you for joining me. See you all in the next session. Thank you.